Let me now discuss the proposed amendment concerning HIV. Section 23(1) of the IDA was introduced in 1992 as one of the public health measures to control and curb HIV transmission. It requires persons living with HIV to inform their sexual partners prior to sexual activity of the risk of contracting HIV from them and to obtain the partner's consent to accept the risk of transmission. This allows the sexual partner to make an informed decision on whether to proceed with the sexual activity and take necessary precautions to minimize the risk of contracting HIV. In practice, doctors regularly inform patients about this legal obligation at the point of HIV diagnosis. The intention of this disclosure requirement was to control the spread of HIV and deter the irresponsible behavior of those that put others at risk of contracting HIV. The disclosure requirement remains relevant as a public health safeguard to protect the sexual partners of persons living with HIV. Section 23(2) of the IDA similarly requires persons who do not know that they have HIV but have reason to believe that they may have HIV to inform their sexual partners of the risk of infection. These safeguards remain and will continue to deter irresponsible behavior, including from those who attempt to hide behind the ignorance of their HIV status. While the safeguards are in place to deter irresponsible behavior, it is important also for our HIV legislation to be aligned with medical advancements in HIV treatment in order to encourage early detection and treatment of HIV. HIV remains incurable. However, with medical advancement in HIV treatment, persons living with HIV who adhere to their HIV treatment as prescribed by their doctors are now able to reduce the amount of HIV in their bodies to an undetectable level. This is referred to as having an undetectable viral load. A person who maintains a stable, undetectable viral load over time as a result of a consistent adherence to their treatment cannot transmit HIV to their sexual partner. The sexual partner, therefore, is not at risk of contracting HIV from these individuals. The amendment bill introduces a provision which excludes persons living with HIV from the disclosure requirement under Section 23(1) if the person has maintained an undetectable viral load for a certain period of time preceding the sexual activity in question. A person is presumed to have done so if certain conditions are met. These conditions are that the person living with HIV adhere to treatment, have stable and consistent undetectable viral load test results from a licensed laboratory in Singapore, and have an undetectable viral load test result within a specified period prior to sexual activity. More details will be set out in subsidiary legislation. This amendment aligns with medical advancements and our public health objective to curb transmission by shifting greater responsibility to individuals to get tested and treated for HIV in order to achieve and maintain a stable, undetectable viral load. The objectives of the amendment are to encourage individuals who are at high risk of getting HIV to be tested regularly for HIV and, if possible, to get treated early so that they can achieve undetectable viral load as early as possible. We urge persons living with HIV to adhere to HIV treatment and monitor their viral load closely with their doctors. In doing so, we aim to reduce the risk of HIV transmission. Singapore is not the first or only country to amend the law on this. Other jurisdictions such as Sweden, Taiwan, United States have removed the disclosure requirement for persons living with HIV who have no risk of transmitting HIV. I would like to emphasize that in proposing the amendments, we are not relaxing the public health safeguards against HIV transmission, but encouraging infected persons to come forward to be tested and treated, thereby better protecting their sexual partners. Irresponsible behavior that can lead to the transmission of HIV remains an offence in Singapore, and appropriate enforcement action will be taken as required.
My final point is on updates to the HIV disclosure laws. Under the new Section 23(1)(a), the disclosure requirement for a person with HIV infection does not apply if he or she has maintained an undetectable HIV viral load for at least the prescribed period preceding the sexual activity. I thank the Ministry for updating our HIV disclosure law to be aligned with the latest scientific understanding. Members of civil society have also shared with me that they are heartened by this development. Can Minister confirm that the length of the prescribed period and the threshold for determining undetectable HIV viral load will be determined and periodically updated based on the latest state of scientific knowledge? Madam, notwithstanding these clarifications, I stand in support of the bill.
Sir, I support the amendment to Section 23 of the IDA, which contains provisions dealing with sexual activity by persons with HIV infection. For too long, the law has lagged behind medical developments, and a proposed amendment to Section 23 will recognize the recognized principle U equals U, or undetectable equals untransmittable. However, I am concerned that the proposed amendment to Section 23 does not go far enough to assist in our journey towards the UN AIDS 90-90-90 targets for 90% of people living with HIV knowing their status, 90% of people living with HIV who know their status being on antiretroviral therapy, and 90% of people living with HIV on antiretroviral therapy achieving viral suppression. As Assistant Professor Dr. Raina Tan from the NUS Sosio Hock School of Public Health argued in a recent CNA commentary, stigma and a lack of access to prevention methods stand in the way of an HIV-free future. The 2023 Global Update by the Joint United Nations Programme on HIV and AIDS has also found that punitive laws are more likely to drive people away from seeking HIV support and services and may be counterproductive to public health efforts. In light of the consensus among public health experts on the ineffectiveness of criminal law in ending HIV, does the government plan to eventually do away with Section 23? If so, can the government explain its decision to tweak Section 23 instead of entirely repealing this law? Sir, I also wish to seek the government's clarification on the duty of disclosure under Section 23 in light of the Singapore High Court's decision in GCP versus Public Prosecutor. In that case, the judge held that even though the accused had only been informed by the public health officer working at the National Public Health Unit that he was required to disclose his HIV-positive status to his sexual partners, the public health officer's opinion of the law was not conclusive. Instead, the High Court held that the plain language of Section 23 means that a person must communicate the risk of contracting HIV and not merely one's HIV status. This judgment has caused confusion among people who are subject to the disclosure obligation under Section 23 as to what would satisfy this requirement to communicate the risk of contracting HIV. What steps have or will the government take to clarify the ambiguity in Section 23? Finally, under Section 23(2) of the IDA, persons who have reason to believe that they have been exposed to a significant risk of contracting HIV similarly have a legal duty to disclose the risk of contracting HIV to their sexual partners or take other precautionary steps before engaging in sexual activity. Can the government provide an update on the number of complaints it has received and the number of investigations it has conducted under this law since it was introduced in 2008? Can the government also confirm if, in light of medical advances, the reasonable precautions under Section 23(2) subsection C will include the correct use of pre-exposure prophylaxis, also known as PrEP? If so, would the government consider amending this subclause to remove the phrase "during the sexual activity" and/or explicitly recognize the use of PrEP as reasonable precaution? If not, can the government explain why not? Thank you.
I note that Mr. Louis Ng as well as Ms. Ting Ru welcomed the provisions in relation to HIV. Mr. Ng asked about the definition of undetectable viral load, length of the prescribed period, and whether these would be periodically updated. I would like to emphasize that the criteria for the maintenance of an undetectable viral load were rigorously determined based on latest scientific evidence and clinical knowledge, after consultation with HIV and infectious diseases experts. Ms. Ting Ru had also raised some other questions. In response, I would say that Section 23 remains relevant to reduce sexual transmission of HIV by requiring persons living with HIV with a detectable viral load and persons who do not know of their status but have reasons to believe that they have HIV to disclose the risk of requiring HIV to their sexual partners prior to sexual activity. This allows sexual partners to make an informed decision before engaging in sexual activities and to encourage responsible sexual behavior by taking mitigating measures such as ensuring condom use to protect themselves. The intention of the HIV laws is not to criminalize persons living with HIV, but to deter irresponsible behavior. She had also made reference to the High Court judgment. The High Court judgment will be superseded by your amendment. In relation to the queries on the prosecution, from 2015 to 2023, 7 people were convicted under Section 23(1) for failing to inform their sexual partners of the risk of getting HIV infection from them. Of the 7, 4 had undetectable viral loads at the time of their offences, and all 4 convictions had aggravating circumstances, including simultaneous offences under the Misuse of Drugs Act, committing a second offence offence or under investigation for a first offence, or the victim was a minor, deceived and exploited victim by lying and posing as a police officer. The law at that time was that a person living with HIV was required to inform their sexual partner of the risk of getting HIV infection from them. This law was now later informed by the state of medical science, and there have since been developments in this, and that's why we're updating the laws to align with these developments. Mr. Speaker, in conclusion, the COVID-19, to summarize, persons living with HIV do not need to disclose the risk of HIV transmission to their sexual partners if they have first maintained stable, undetectable HIV viral load consistently below 200 copies per milliliter of blood for at least 6 months based on test results from a recognized laboratory. Second, their most recent undetectable viral load test result should be 9 months or less before the sexual activity in question. Third, they had adhered to medical treatment for HIV infection up to the time of the sexual activity in question. Persons living with HIV who have met these criteria would have effectively zero risk of transmitting HIV to their sexual partner. We will set out the criteria in subsidiary legislation to allow for timely and responsive adjustments should the state of medical science change in the future.
Thank you, Speaker. I just want to add on amendment to Section 23. I think we are keeping 23 because it's still relevant for those who are infected or who think they are infected. They have continued to have obligation to inform, but at the same time provide an exemption for those who have tested, sought treatment, and then lower themselves to an undetectable, untransmissible level. We think this combination best protects public health. Other countries might have come to a different condition, but I think in terms of MOH, we studied together with the experts, and we find that this combination probably best protects public health. As SPS, Madam Rahayu have answered all questions. I have nothing further to add.
Thank you, Speaker. I have two quick clarifications. The first is, I thank SPS Rahayu for acknowledging, for saying that the GCP and VP actually supersedes, the amendments supersede the ruling in GCP versus public prosecutor. I acknowledge that the amendment supersedes the court sentencing framework. However, I'm not clear that it deals with the interpretation of meaning of risk of disclosing HIV, so I'd like to ask for further clarifications about that. What specifically, in particular, are the people living with persons living with HIV are supposed to do in that context? And I think the second point that I wanted to seek further clarifications on is that I don't believe that there's any local study on the effectiveness of criminalization of HIV non-disclosure on reducing HIV infection rates. Albeit this time is, we're talking about a reduced group of people that this applies to, and I'm just wondering, whether or not what can MOH do to address the potential stigma that might arise from this continued criminalization? Thank you.
I thank member for the question. In relation to her point, actually how this works is that when a complaint is made, actually the person investigated for the offence would then be able to produce the necessary evidence or show what it is meant by the UVL that they have, had. And so when at that juncture, the strongest evidence for the adherence of medical treatment would be the UVL test result from a recognized laboratory at the next regular medical checkup, medical follow-up visit for HIV after the sexual activity in question, because it will show that that they have maintained their UVL, because this would not have been possible without treatment. And there would be other circumstantial evidence for adherence for treatment that may include contemporaneous records at the next follow-up visit after the sexual activity in question, or documented treatment adherence, or documentation in past medical records of a consistent pattern of treatment adherence, and consistent past UVL test results carried out by a recognized laboratory. These are the things that they would have to show in the event there's a complaint made and investigations follow. In as far as how they would conduct themselves, the reality is that this is a law provision that says you are not supposed to do it. So if they then do this and there's a complaint made, investigations will follow, and these are the provisions and the evidence that they can rely on. On your second question, the criminalization of non-disclosure. So the amendments actually consider the established scientific evidence that transmission risk with an undetectable viral load is effectively zero. That's the premise upon which we're making this change. In contrast, other sexual activities, will actually, although lower risk, have pose some transmission. So we will not want to change our position completely on this, because what we are doing is really based on data, based on evidence, and requiring disclosure of the risk of acquiring HIV prior to sexual activity allows their sexual partners to make an informed decision before engaging in sexual activities and be able to then take the mitigating measures such as medications to protect themselves.